Good morning, Mr. Grunebaum.
Good morning. As you've indicated, my name is David Grunebaum. I represent the City of Lynn, the appellant in this matter.
Thank you. Good morning.
This is an appeal of an arbitration award brought pursuant to Chapter 150C, Sections 11 and 12. However, this particular case is unique and different from other appeals of arbitration awards in that it is also brought pursuant to Chapter 8 of the Acts of 1985, commonly referred to as the Lynn Bailout Bill. Finally, it's a request for declaratory judgment, as these statutes need to be reconciled.
And Mr. Grunebaum, if I could, let us imagine that the City of Lynn had received $300,000 additional in funds which were wholly unrestricted, exactly as was contemplated by the contract, and they decided to spend them for other purposes other than increasing the salaries to the pre-agreement level. Would you still be here?
I think I would, Your Honor, and I would say that because my reading of Chapter 8 is that you need an appropriation prior to an expenditure. So assuming we had received unrestricted funds, and that's what the arbitrator essentially finds, and while we disagree that they were unrestricted funds, for the purposes of this case, that would be a hard argument for me to make in light of arbitrational decisions that this court has rendered. But I would say you need to have an appropriation under Chapter 8 designated for the police department and designated as appropriations are for a purpose. There was no appropriation for gun money, uniform allowance, and similar items. So I would say I would in all likelihood be in the same position.
Well, Mr. Assuming that's the case, it seems to me there would be, you signed, or the city signed the MOU, there would be no circumstance in which the conditions of the MOU could be brought to fruition. Is that right?
I would argue, Your Honor, that this is not dissimilar from the cases that this court has decided with regard to minimum manning. Contracts, collective bargaining agreements, often contain clauses setting minimum staffing levels in the fire department most typically, and that's where your cases come, but also in teacher contracts. And there, this court has held that that the remedy for a violation, that there is, until there's an appropriation, there is no obligation, and until there, the remedy is that you go to court and you order the mayor to seek an appropriation, but it still rests with the legislative appropriating body, in this case, City Council.
But the MOU says, does it not, that if money is received by the city from the Commonwealth, then the city will use it to sort of fill in the concessions, correct?
That's correct.
So the city entered into that MOU, said if money is received from the Commonwealth, we will do this. Are you saying that the city knew at the time that there was no way that could be carried out? Because, of course, money received from the Commonwealth would not be a City of Lynn appropriation.
Yeah, I have to, because I'm not part of the discussion at the time of the MOU. So whether they knew or didn't know, if you're asking me as a factual matter.
No, I'm not asking you as a factual matter.
But as a legal matter, I would say that whether or not they knew that there is a remedy here, and that is to go to the legislative body and obtain an appropriation. And I'm only saying that this arbitrator could not order us to pay the money and circumvent the appropriation process, which is critically important in Lynn.
But
So what happened
did he order you to circumvent the appropriation process? All he did was order you to pay the money. He didn't tell you how.
Well, he orders us to pay the money. There's no question on that. And if there is no appropriation, you can't pay the money.
But there could be later on. He didn't tell you how to pay it.
Well, you can't. Under Chapter 8, you need an appropriation, and you cannot if you will, swing forward the obligation to a subsequent budgetary period.
Well, this is a breach of contract, though. I mean, isn't this a breach of contract, essentially? And of course you can be ordered to pay damages under a contract, and you have a judgment account, and you've got all kinds of ways in which judgments get paid.
Well, let me say, this particular judgment is a judgment ordering wages, and wages are treated differently under Chapter 8. Chapter 8 says, in the absence of an appropriation, you have no obligation to pay the wage. As to the judgment issue, that judgment occurs in a subsequent fiscal year.
Often they do?
Yes, and the way you deal with that is you have to go back and get an appropriation. In Lynn, you specifically have to get an appropriation for a wage judgment because that's what Chapter 8 says. If you will, Your Honor, Chapter 8 really makes a dramatic change in Lynn as opposed to other communities.
So are you saying that the memorandum of understanding that the mayor and the union and the police entered into was essentially void,
No.
meaningless?
No, I'm saying it was, as the collective bargaining agreement is, subject to the strictures of Chapter 8. Chapter 8 requires by its terms that it be included in every collective bargaining agreement. And Chapter 8 further says that every collective bargaining agreement is subject to, or I would say subordinate to, the strictures of Chapter 8. So this is a collective bargaining agreement, not a contract for services like the construction of a school.
So the mayor agreed on behalf of the city and simply decided not to follow through.
Actually, I think
not to comply with the agreement.
No, I think what happens here as a factual matter is the chief of police makes a determination that this particular grant of money does not fall within the strictures of the contract, and he therefore doesn't do anything. What happens then is that the union, in February, the money comes down in December, the union discovers it, or however you might describe it, raises the issue in February, and at that point the chief, believing that this is not unrestricted money because of the supplantation versus supplementation language, which I describe a little in the brief, but which I do not, it's not...
Not here.
It's not directly here, because I felt that was the kind of interpretation of law that an arbitrator could make, and whether I agree with him or not, I don't get it here. But the chief makes, I think, a good faith determination. There's no question in anybody's mind. He makes a good faith determination. It does not fall within the MOA. Then we get an arbitration which arises almost a year and a half later in the summer of 05. This begins in the winter of 03, 04. And a decision in 05, which is an FY06 decision, becomes, I think, actually an FY07 judgment, but even the decision is FY06. And at that point, you can't pay it under at the beginning under Chapter 8, but you certainly can't go back.
Now that you have a judgment, I mean, you're saying all of this occurs afterwards, so now you have a judgment. Don't you have an obligation to essentially get the money?
No, I think the answer is we have the award.
You can get it without violating Chapter 8, which is essentially what the deal is.
I actually do not. The answer is that the mayor can go and ask for it, but that doesn't give him the money.
But what about the part of Chapter 8 that talks about one of the exceptions to the stricture is that a retroactive compensation adjustment? Why isn't that what this is?
I read that as dealing with contract formation, and contracts in police departments can be formed in two ways. One is through voluntary negotiation ending an agreement. If that occurs, the mayor must, the city must go back to its legislative body, the city council, and seek an appropriation. And if the appropriation is denied, the contract is down. The second way it occurs, and I think that's really where this language is directed, is that you can go to the Joint Labor Management Committee where an arbitrator can issue an award of creating a contract. That award, again, is subject to appropriation. And those things typically happen in the public sector in cities and towns, often 1, 2, and even 3 years after the expiration of the old contract. So this is simply saying in that circumstance, you're not explicitly prohibited from seeking an appropriation from the legislative body. You can go back to the legislative body in that circumstance, seek an appropriation, but as always, if the legislative body denies the appropriation, then the contract is without
Did you ever
effect.
seek to fund this award from
We
the
did
legis-
not. We did not.
Because?
Counsel,
Can you just go?
Can I answer hers and then come back to you, Your Honor? The answer is twofold. First of all, because I think the award is not in effect. Secondly, I have a 30-day period to file an appeal. I don't want to overstate that, but you have to make a decision within that 30 days whether to appeal the award or not. And it's not as though you can come back later and say, well, we didn't get the money, so let's appeal the award. That's a jurisdictional. So we made a decision that the award was an error. It caused a violation or it ordered a violation of Chapter 8, and we therefore determined to bring this appeal, or what eventuates into this appeal.
Justice Ivor?
now, I'm interested in this specific language that was in the MOA. It said, in the event the city receives additional assistance from the state or federal governments during fiscal year '04 that improves the city's current financial situation, the concessions made by the union shall be reconfigured proportionately to repay the officers up to the amount of the concessions. Isn't that an agreement?
It is an agreement, Your Honor.
Why shouldn't the city be held to the agreement?
Your Honor, all agreements, all collective bargaining agreements, whether this one, which is an amendment yes, it's an amendment to the underlying contract, which is also there, are subject to Chapter 8. Chapter 8 requires its inclusion, and Chapter 8 says all agreements are subject to its provisions, and Chapter 8 requires an appropriation to pay the money. So you have to read this MOU as saying, provided you can do so in compliance with Chapter 8, because that's what Chapter 8 says.
Does the arbitrator's award order an appropriation?
It orders payment of the money.
Yes.
Mr. Gruner, forgive me for interrupting you, but I just want you to, as you answer Justice Cowen's question, obviously your opponent says that the award directs the city to decide how to comply with its obligation under the Memorandum of Understanding without violating Chapter 8, which I think is the import of Justice Cowen's question, which is, if you say that in order to avoid for the city to avoid violating Chapter 8, you're going to ask for an appropriation, and if they don't give it, then you have complied with the arbitrator's order.
If I might, Your Honor, distinguish between what I read as his opinion and his award.
Okay.
In his award, which is much shorter and which is what is here on appeal, he simply orders payment.
Okay.
In his discussion, he says, pay the money in accordance with my award and do so within compliance of Chapter 8. I would argue, Your Honor, that's a bit like saying, fly to the moon but stay on the earth.
Did you move before the arbitrator to clarify that his order be consistent?
We did not.
Again, I'm not trying to find procedural hurdles that over which you didn't jump, but typically, in many situations, arbitrations and others, there's an order, and then there's a memorandum of decision, and if there's an inconsistency between the two, the party will seek clarification.
The difficulty I perceived at that time
Right.
was that as I say, I have a very short statute of limitation.
No, I understand that. And you can always, file a notice of appeal and in the alternative do something else, and then somebody says you shouldn't have done it. We hear that all the time.
We clearly could have done that. We did not do that. We appealed because we saw the order in itself as requiring a payment, and a payment which we could not make, there being no money. As I indicate, there is no money at that point. At the end of the year, the police department was actually, if I can back up, the money is actually used in part for a match for other funds. Had we used the $277,000 to pay these amounts, we would have actually been even shorter because we would not have had the match available
I
for
understand.
a federal fund. So it would have exacerbated it.
May I ask this related question? You got this $277,000 grant from the Executive Office of Public Safety
Yes, Your
for the police department.
Yes, Your Honor.
Did you then seek an appropriation so that you could spend that money, or could you just spend it without appropriation?
My understanding is that money did not require an appropriation, but I don't know. The record does not answer that question. I don't know the answer, and I don't want to just take a guess here.
Mr. Grunebaum, you mentioned, or your argument seems to be that this is based on Chapter 8. If this were not the City of Lynn, or if Chapter 8 had not been enacted, and we merely had the scheme of general laws, could the arbitrator have ordered payment of those restricted funds for the purpose for which the police department sought?
I think he could have. I'm not arguing a broader. I'm arguing, quite candid, this is Lynn, this is Chapter 8, and it's that collision, Chapter 8, with other obligations that creates the problem here. So, yes, I think if it were Cambridge or Boston, assuming they don't have any special legislation, yes, I think they'd have to pay.
Thank you, Mr. Grunebaum. And unfortunately, that little red light starts to flash, and in fact, it's stopped flashing because it's gone way over. But I can assure you, we will read everything that you've submitted, Mr. Grunebaum.
If I can just sort of
I'm afraid, I know it's incredibly harsh, but I've got a lot of people here, and 15 minutes is sort of 15 minutes. But thank you.
Thank you, Your Honor.
And I will be just as strict with Mr. Becker. Good morning, Mr. Becker.
Morning, Your Honor. May it please the court, John Becker.
Sorry, what do you say, Mr. Becker, to the to Mr. Grunebaum's argument that the award orders payment?
The award does not order payment. It orders, well, the award orders.
Could you finish that? It does not order payment?
I'm sorry.
It does not order payment?
There's a sentence, the city must comply with the MOA by repaying the bargaining unit
It does order
employees.
payment. I'm sorry.
So
I
how do you-
misspoke.
Okay, so
Then how can you rely on that provision that says they've got to figure out a way to comply with Chapter 8?
Well, it doesn't say how they have to pay. It doesn't say what fund they have to pay it from. It doesn't say what mechanism they have to use. It doesn't say whether they have
But
to.
isn't that implicit? The whole agreement was based upon if they get other monies.
Right.
Was there any issue before the arbitrator that there were monies other than these $270,000?
There were not.
So
no.
isn't that the issue? Is whether these $270 have to be ordered to be paid?
Right, and that was the order. The order was to pay those monies, and
Would you agree that these are personnel expenses?
I think they can be characterized as personnel expenses. Yes.
Don't you think that, the legislature has said, Lynn is in a great deal of difficulty, correct?
Right.
So the Commonwealth has to come in and bail them out, right?
Right.
Which means that it's other people's tax dollars that are going to bail out Lynn for whatever reason, right?
Right.
And the legislature says, Lynn, don't do anything that violates Chapter 8, correct?
Yes, but
Then every memorandum of understanding into which it enters is subject to Chapter 8, correct?
Yes, but the converse is true as well, which is when they entered into the memorandum of understanding, they were aware of their obligations under Chapter 8.
It doesn't matter.
They were
If
aware
they
that
can't enter into, I mean, then you get into whether this is an illegal contract, and there's no claim here,
No.
right?
I think that what you need to do is to look at what are the purpose of what is the purpose of Chapter 8?
Right.
Chapter 8's purpose is to rein in irresponsible spending by department heads. When you look at the way that it's written, it's all about department heads. We have two exceptions that one of them, Justice Bosford pointed out, the subsequently determined retroactive pay adjustment exception. And there's also an exception for the mayor to go beyond the restrictions of the allotment period by period. Those are there to avoid harsh and nonsensical requirements that or results that would come from applying Section 8, from interpreting it the way that the city would like to interpret it. You have a situation now where, if, for example, a court came down with a judgment of back pay in a MCAD complaint, according to their interpretation, they wouldn't be able to pay it. It doesn't make any sense. There's got to be a way in which Section 8 can coexist with payment of breach of contract, as Justice Cordy pointed out, with payments of judgments.
Well, let me go to your MCAD one. I really, that's a different case, but I don't know what would happen if the city of Lynn, and I'm not suggesting it did, engaged in egregious misconduct, violating people's civil rights and so on and so forth, and didn't have the money to pay. I don't know what happens in those situations. There could be an order to pay, but you've still got Chapter 8, and you have to harmonize those. But it seems to me that just because it's an order doesn't automatically trump.
Well, in the very least, in this case, Your Honor, there was an obligation on the part of the city to go to seek an appropriation. I think
is perhaps your best argument that the arbitrator's award that orders the city to comply with the MOA by repaying, that simply that Chapter 8 doesn't prohibit the payment of awards for breach of contract? Is that your best argument?
Well, that's certainly one of our arguments, and we've set that out in our brief, and it was also one of the appeals court's arguments.
How do you respond that if these payments had been made, that the city would have had to match the funds?
Would have lost the match. If these funds had been used to pay off the MOA, I don't know, Chief,
right.
Maybe it's a different question. It would have essentially lost the match and would have cost the city a great deal more.
My argument is that the arbitrator found that was not a problem, and that his findings of law and fact.
What's the basis of the arbitrator making that?
I mean, I take it, wouldn't you say that it's irrelevant in that if there's an MOU that says if you get funds from the Commonwealth or the federal government, you need to use them for this purpose?
I think that would be my answer, and I
Can I ask you this?
the help.
Let's assume in real time, we're looking back to 2003 in November or December. The city gets this $277,000 grant. They've just negotiated $290,000 in concessions. The mayor approves the use of the 277 to pay back some of the 290.
Right.
Doesn't seek an appropriation for it.
Right.
Exercises this power to exceed the allotment. But at that point, then the appropriation for the police department will clearly be out of whack, the yearly appropriation.
Yeah.
Clearly, they'll have been spending in excess of appropriation. So what happens then?
I don't know. I'm not sure what the Section 8 is not specific enough about what kind of a situation would occur there. I mean, according to Section 8, if you're...
Section 8 or Chapter 8?
The bailout bill.
The bailout bill.
Okay, I'm sorry.
Chapter 8,
Yeah.
yeah, I'm sorry. According to the bailout bill, you can't spend anything in excess of appropriations. So that would get, but here's the thing, we don't have the answer to that question because that's essentially what happened. They brought in this grant. The grant money obviously got spent, and no one seems to have had any negative consequences as a result. So this is sort of the missing piece of the puzzle, that they were able to bring in the grant, so they were able to spend money in excess of appropriations without any negative consequences that we've heard of, at least.
So if it hadn't been used to match federal funds, but had been used to pay personnel expenses that were otherwise budgeted for, you say it would be the same outcome.
Yes. I mean, the municipal governments all the time are seeking grants and getting grants. And the idea that every time one of these grants comes in to a department, they're violating Section 8 just doesn't make any sense.
I'm not sure I understand why this grant wouldn't be subject to some form of appropriation, but I just don't understand the dynamic in Lynn.
My understanding is that it was not appropriated, but I defer to Mr. Grunenbaum on that point.
Excuse me, the matching funds were not appropriated? What wasn't appropriated?
The grant itself. As I said, I defer to Mr. Grunenbaum, but my understanding was that there was no appropriation of the grant.
Why wouldn't the use of the grant money, which was restricted in its use, why wouldn't the use of the grant money for purposes of the Memorandum of Understanding have been a violation of the terms of the grant?
That's a question that was addressed to the arbitrator, and the arbitrator decided that it was not a violation of the grant, and that decision of the arbitrator, that finding of law, is not under review at this point.
No, I don't think the city has challenged that either.
No.
So how, you say this $277,000 in funds were spent without appropriation to match federal money. How was that money spent? Was it spent on police operations, police overtime, stuff like that?
My understanding is it was spent on police operations, and was some of it at the end of the
Dues
year.
for the International Order of Police Chiefs.
That was part of it. It was a number of different police-related functions. Some of them were directly given to the rank and file. Others were for the management.
Some was spent for overtime, wasn't it?
So I think there was some was spent for overtime, and I believe there was some money that was given back at the end of the year as part of the memorandum of agreement. If there was anything left in the budget, they were supposed to give money back at the end of the year. Now, whether that money was part of the grant or not, I'm not really sure, but I know that there was some money given back at the end of the year.
Mr. Becker, the arbitrator said there wasn't a violation of the grant. Let's say the grant awarder disagrees. It is not part of this arbitration, so it sues the city, says you violated the terms of this grant because, as Justice Pena suggested, here are the restrictions. What happens? Cities are scrambling all over to get money from almost any source, correct?
So the grantor says you're using it for the wrong purposes,
Yes.
and we
We
want our
didn't
money
have an
back.
obligation to pay increased wages for your police officers. What we're trying to do is target best practices, community policing, more use of technology. I mean, that's what people are usually giving grants for, not to supplement the wages.
Well, one thing that I think that would be brought out in any such litigation would be the fact that the city, when it applied for the grant, when it was asked which members of the department are specialized in community policing, it listed everyone. And I think that was one of the factors that the arbitrator found persuasive when he said that this community policing grant, by going to supplement the pay of everyone, would be in fact serving the purpose of the grant. Now, whether the grantor would ultimately agree with that, or whether a neutral party would adjudicate which way that would come out, I can't say.
But in any event, well, I take it what you're saying is that that's water over the dam, because the city hasn't contended that, or doesn't contend on appeal, that was outside the scope of the arbitrator's power.
That's correct. The case law in this city of Lynn versus Thompson, for example, is very strict that arbitrators' rulings of law and findings of fact are
But we know that
sacrosanct.
very well. They can be as long on the law, as long on the facts, and there's very little we can do about it, correct?
That's correct. And so if they were wrong on the law, if the arbitrator was wrong on the law about the nature of this grant, that's not something that's subject to review here.
Mr. Becker, could you just explain one thing which I think I don't understand? Maybe when you talk about it, I will understand it. When you were discussing in your brief that the arbitrator instructed the city to decide how to comply, you know that little sentence, how you're going to comply
Yes.
with the MOA without violating, you said there can therefore be no claim that this award explicitly requires the city to violate Chapter 8. And then you said the arbitrator also retained jurisdiction of the matter in order to resolve any questions. Instead of invoking the arbitrator's jurisdiction, the city instead filed this petition. Are you suggesting that the question that I put to Mr. Grunebaum, did you go back for clarification, that's what they should have done?
Yes, I think that would have been an appropriate thing for the city to do. The city.
Had they done that, did they necessarily have to file an appeal within 30 days to protect its rights, city?
I think that would extend the appeal time, Your Honor, but I
And
I
what
don't.
if, and
I
would
don't
you
have
be
that
here
research.
arguing that it didn't?
Yes.
I don't know.
You don't need to answer that.
I don't
Well,
know.
he does need to answer it, because if in fact you are suggesting a form of relief that would have, I mean, sometimes you can go both routes, but sometimes if you go both routes, you necessarily eliminate one of them.
I can't honestly say that I know what the answer is, Your Honor, without further research.
Well, could they have gone both routes?
That's certainly possible. I mean, the arbitrator.
And we would have said, go back, finish before the arbitrator.
Right.
Okay. Thank you, Mr.
All right.
Becker.
Thank you, Your Honor.